A senior citizen stood at a gun range counter last week and waited nearly an hour just to complete routine paperwork that should have taken 10 minutes. A few feet away, someone half their age walks straight through the entire process with a single card and zero delay. And right now, at this very moment in February 2026, there are retired police officers across America who still don't realize they can legally carry concealed firearms in all 50 states without obtaining a single state-issued permit. Not because they don't qualify, not because the law doesn't allow it, but because nobody in the firearms industry, nobody in government agencies, and nobody in the advocacy organizations that claim to fight for gun rights ever bothered to tell them this protection exists. This is about 10 firearm rights written specifically for older Americans. Real legal protections, reduced fees, waived requirements, and training credits that exist in federal and state law right now in 2026. But the system doesn't advertise them. Gun stores don't mention them. Even organizations like the NRA that should be screaming these benefits from the rooftops keep them buried in fine print where most seniors will never find them. Why? Because when older Americans don't know their rights, when they overpay for services they shouldn't be charged for, when they jump through bureaucratic hoops they've already earned the right to skip, someone else profits. And one of these protections, one single legal safeguard on this list, could be the difference between walking free after a defensive gun use and facing serious criminal charges that destroy everything you've spent a lifetime building. These aren't loopholes. These aren't tricks. These are legal rights you've earned through decades of responsible gun ownership, through service to your community, through simply reaching an age where lawmakers recognized you deserve accommodation and respect. But they've been deliberately kept quiet because an uninformed senior citizen is a profitable senior citizen. If you're tired of being treated like you don't matter, if you're sick of paying full price while younger gun owners get breaks you've never even heard of, subscribe to this channel right now. Hit that button and turn on notifications because what I'm breaking down today is information the firearms industry and government agencies actively avoid circulating widely. They want you uninformed, overpaying, and completely unaware of protections that could save you thousands of dollars or keep you out of legal trouble that could end your gun rights permanently. Don't let them win. Subscribe now and let's expose what they've been hiding from the Americans who've earned these rights more than anyone else. Let's start with something almost nobody in the RV community talks about, and the silence around this issue has led to criminal prosecutions that never should have happened. Your recreational vehicle, that motorhome you've been traveling the country in during retirement, might be more than just transportation. Under the right conditions, in the eyes of the law, that RV could be your legal castle with all the constitutional protections that come with it. If retirement means life on the road, if you're living in a motorhome full-time or even part-time, that vehicle may be doing more than just getting you from one campsite to another. Here's what almost everyone misses entirely, and this ignorance has destroyed lives. When your RV is parked, when it's plugged into utilities at an established campsite or RV park, when you're using it as a temporary residence, it falls under Castle Doctrine protections in the majority of states. That means you're legally allowed to keep a loaded firearm inside for personal defense, exactly the same way you would in a traditional house. That shotgun under your bed when you're camped for the night? Completely legal in most jurisdictions. But the moment you turn the ignition key and start driving down the highway, the rules flip entirely and without warning. Now your RV is classified as a vehicle under state transportation laws, and that same firearm that was perfectly legal 2 minutes ago must be unloaded, locked in a case, and stored in a manner that makes it completely inaccessible to you while the vehicle is in motion. If it's within reach and you get pulled over in the wrong jurisdiction, you're not looking at a ticket or a warning. You're looking at potential felony weapons charges that will strip your Second Amendment rights for the rest of your life. Think about how insane that is. The same firearm in the same location becomes legal or illegal based solely on whether your engine is running. Thousands of seniors travel this country every year in motorhomes without ever realizing this legal minefield exists. They assume the rules are consistent whether they're parked at a campground or driving through Montana. They're not. The key takeaway here is simple but absolutely critical to your freedom. Treat your motorhome like a vehicle when it's in motion and like a residence only when it's fully parked and serving as your living quarters. One wrong assumption about this distinction, one moment of confusion about which legal framework applies, could turn a peaceful cross-country road trip into a criminal prosecution that destroys your Second Amendment rights permanently. And here's the part that should make your blood boil. Campground staff won't tell you this. RV dealerships won't mention it when they sell you a $200,000 motorhome. You're just expected to know, and when you don't, when you make an honest mistake that millions of Americans could easily make, the consequences fall entirely on you. Now, let's talk about senior discounts that absolutely exist in the gun rights world, but that most older Americans never hear about. And it's not because these programs are secret or hidden in some legal gray area. They're official programs run by the largest firearms advocacy organizations in the country. But these groups offer massive lifetime membership discounts specifically for seniors that they rarely promote upfront or advertise prominently. Why not? Because full-price memberships bring in substantially more revenue from people who never think to ask if there's a better rate available based on their age. Take the NRA as the clearest and most egregious example. They offer what's called a Distinguished Life Membership specifically designed for seniors. If you're 65 or older, you can lock in a lifetime membership for $500. The regular cost for anyone younger? $1,500. That's a $1,000 difference just for hitting the right age bracket, and they don't advertise this aggressively because they'd rather collect the full $1,500 from seniors who don't know to ask. The Second Amendment Foundation offers lifetime memberships to anyone for only $150, and Gun Owners of America runs similar age-based deals that slash prices dramatically for older supporters who actually know these programs exist. These memberships come with real, tangible benefits that matter. Monthly magazines, substantial gear discounts, exclusive access to training resources, participation in legal defense programs, and in some cases, firearm insurance options that could save you tens of thousands of dollars if you ever face criminal or civil charges related to a defensive gun use. But here's the catch that should make you furious. Most people never hear about these senior rates because the organizations don't shout it from the rooftops. They don't send you emails on your 65th birthday saying, "Congratulations, you just qualified for a massive discount we've been hiding from you." You have to ask. You have to call or email the organization directly, let them know your age, and then watch the membership cost magically drop by hundreds or even $1,000. Sometimes all it takes is one question, one phone call, to stop overpaying for benefits you've been loyally supporting for years or even decades. So if you're a senior and you support gun rights organizations financially, don't hand over full price without checking first. Make them tell you about the senior rates. Make them justify why they weren't planning to mention it until you asked. Hold them accountable for treating their most experienced supporters like revenue sources instead of valued members. Here's another protection written into federal law that gun stores will never advertise because it's inconvenient for their business model. Seniors are legally entitled to more time and reasonable accommodation when purchasing firearms, and the vast majority don't know this right exists. Walk into any gun shop in America, and chances are nobody behind the counter is going to mention this. But under the Americans with Disabilities Act, age-related conditions like slower mobility, hearing loss, vision difficulties, or even just needing to process paperwork at your own pace without being rushed are all federally protected. That means you cannot be hurried, pressured, or refused service just because you take longer or need a little extra help filling out the required forms. In plain terms, needing more time to complete ATF Form 4473 isn't a problem that should embarrass you or make you feel like a burden. It's a protected right under federal law. If your background check takes longer than expected, you can't be treated like an inconvenience. If you ask for help reading fine print or understanding a confusing section of the paperwork, the store is legally required to provide reasonable accommodation, period. There's a documented case out of Arizona where a 72-year-old man was nearly denied a handgun purchase because he was taking too long with the paperwork. The staff made him feel rushed and unwelcome. He calmly cited his rights under the ADA, and the store immediately changed its approach and completed the transaction properly. But think about what would have happened if he didn't know those rights existed. He would have been denied, humiliated, and sent home without the firearm he had every legal right to purchase. Here's the part that should infuriate you. This right isn't advertised anywhere in gun stores. Why? Because stores don't want longer transactions. Time is money in retail, and if helping you properly cuts into their efficiency metrics, if accommodating you means the next customer has to wait an extra 5 minutes, they'd rather you didn't know you're entitled to that help. Your constitutional rights don't disappear just because they're inconvenient for someone's profit margin. So if you're over 60 and you feel rushed or dismissed during a firearm purchase, speak up immediately. Use this exact phrase: "I'm requesting reasonable accommodation under federal disability law." That one sentence is often all it takes to stop the pressure and completely reset the conversation. Now we need to address one of the biggest and most damaging myths in the firearms world. A lie that causes too many seniors to voluntarily surrender their constitutional rights for absolutely no legal reason. The false belief that being older automatically means you lose your gun rights. Let me set the record straight with complete clarity because this matters more than almost anything else I'm going to tell you today. There is no federal law that says you're too old to own a firearm. Not at 60, not at 70, not at 90. Age by itself is never a disqualifier under federal law. But countless older Americans wrongly believe that getting older automatically triggers some kind of gun rights expiration date, that hitting a certain age means you're legally required to surrender your firearms. That's categorically, demonstrably false. Here's what the law actually says, and this is absolutely critical. The only way your firearm rights can be legally stripped from you is if a judge formally declares you mentally incompetent through an official court proceeding with due process protections, not just a doctor's opinion, not just taking medication for anxiety or depression, not because you're getting help managing your finances, not because you live in assisted housing or use a walker or wheelchair. Even in cases of legal guardianship, many states still explicitly protect your Second Amendment rights unless there's been a specific court ruling saying otherwise. Federal courts have made this abundantly clear in multiple rulings. Age-related decline on its own is never sufficient grounds to strip constitutional rights without a formal legal proceeding. So why isn't this more widely known? Because when people are scared and uninformed, they're easier to control. And once someone voluntarily gives up their rights, once they hand over their firearms thinking they're required to by some law that doesn't actually exist, getting those rights back becomes a long, expensive, and extremely difficult legal battle. Here's the bottom line that every senior in America needs to understand. Unless a judge has officially declared you mentally incompetent in a court of law with all the constitutional protections that entails, your right to own and carry firearms remains fully intact regardless of how old you are. Don't let family members talk you out of your rights just because of your age. Don't let nursing home administrators pressure you into surrendering guns based on facility policies that have absolutely no legal weight. And absolutely don't let anyone convince you that turning 70 or 80 somehow triggers an automatic disqualification that doesn't exist in any federal or state law. If you're starting to realize how much you didn't know about your own legal protections, if you're understanding how many rights you've been leaving on the table because nobody told you they exist, then subscribe to this channel right now. Hit that subscribe button and turn on notifications because the next videos break down the exact legal language to use when police ask about firearms during traffic stops, the specific state laws that protect home defense, and the insurance programs that could save your financial life. Don't wait until you're in handcuffs or facing a lawsuit to start learning this information. Do it now while you still have time to prepare. Here's something else that could save you hundreds of dollars and hours of unnecessary training time, and almost nobody in the firearms community talks about it. That old hunter safety card you earned decades ago, maybe back in the 1960s or 70s or 80s, might be all you need to qualify for a concealed carry permit without taking another class. If you completed a hunter safety course years ago as a teenager or young adult, don't toss that certificate in a drawer and forget about it. In 2026, it might be your golden ticket to skipping modern concealed carry training requirements altogether. A surprising number of states still accept hunter education certificates as proof of firearms competency for concealed carry permits. That means you could qualify for a concealed carry license without having to sit through another expensive class, or pay for mandatory range time that teaches you things you've known and practiced for 50 years. States like Wisconsin, Virginia, Idaho, Arizona, and Oregon explicitly list hunter education as an acceptable alternative to modern concealed carry courses. And here's the best part that makes this even more valuable. It usually doesn't matter how old the certificate is. If it was issued through a state-approved program, it still counts today in 2026. Think about what that actually means in practical terms. You already learned safe handling, legal responsibilities, and marksmanship principles back then. Those core fundamentals haven't changed in any meaningful way. So if you've been hunting safely for decades without incident, there's an excellent chance you already meet the training requirements most states are looking for. Instead of spending time and money on a class covering material you mastered half a century ago, call your state's concealed carry licensing office directly and ask them if your hunter safety card qualifies as proof of training. You might discover that your certificate from 1972 is just as valid today as it was when you earned it. Why pay for something you've already demonstrated competency in? The system is absolutely counting on you not asking that question. And while we're on hunting, here's a benefit that flies completely under the radar, but could save you money every single year. If you're 65 or older, you might not have to pay a single dollar for a hunting license ever again. Not a discount. Full-on free hunting privileges in many states. Take Florida as a clear example. Once you hit 65 and you're a resident, your regular driver's license effectively becomes a universal hunting and fishing pass. No separate license needed. You're covered, including tags for deer, turkey, and other game species. Georgia has its own version of this. If you were born before January 1st, 1961, you're automatically exempt from hunter education requirements entirely. And it's not just those two states. Dozens more have similar cutoff dates or hidden senior exemptions buried deep in regulation handbooks that nobody reads unless they're specifically looking for them. Why do these programs exist? Because lawmakers recognize that seniors are often on fixed incomes, and frankly, older hunters tend to be substantially more responsible and safety conscious than younger shooters who haven't spent 50 years in the woods learning from real experience. But don't expect to see these benefits advertised on billboards or promoted prominently in sporting goods stores. Most people only find out if they go digging through dense wildlife regulation documents that most Americans will never read. So here's your move. Head to your state's Fish and Wildlife Agency website and look specifically for the Senior Citizen Benefits section. You might discover that the $150 annual license you've been paying loyally every single year is something you've already earned the right to skip entirely. Here's another financial perk that could save you hundreds of dollars if you know where to look and who to ask. Concealed carry permits get significantly cheaper as you get older in several states. But most folks over 60 never even hear about these reduced rates. States quietly offer senior discounts on concealed carry permits, and we're not talking about trivial savings. In Louisiana, anyone 65 or older pays exactly half price. A 5-year permit that normally costs $125? Seniors get it for just $62.50. And if you want the lifetime permit option, it's $250 instead of $500. That's a serious financial break that adds up substantially over time. Alabama recently launched a lifetime pistol permit program where the regular price is $300, but if you're 60 or older, you pay just $150. Texas also provides discounts on renewals to seniors, cutting costs and reducing administrative red tape in the process. These savings accumulate quickly over the years, and they mean fewer renewals, fewer background checks, and substantially less paperwork as you age. But here's the infuriating catch that you need to understand. Most states don't go out of their way to advertise these senior-specific rates. If you don't explicitly ask, they'll gladly charge you full price and pocket the difference without ever mentioning that a discount existed. So before you apply for or renew your concealed carry license, take 60 seconds to contact your state licensing office and ask directly about senior rates and lifetime permit options. The law might already be on your side. You just have to know to ask the question. And if they don't volunteer the information immediately, press them harder. Make them explain why they weren't planning to mention the discount until you specifically asked about it. Now here's a benefit that even many retired law enforcement officers don't realize they have, and it's one of the most powerful concealed carry protections in federal law. If you're a retired police officer or federal agent, there's a provision built into federal law that gives you concealed carry rights across the entire nation without needing individual state permits. It's called LEOSA, the Law Enforcement Officers Safety Act, and it grants qualified retired law enforcement the right to carry a concealed firearm anywhere in the United States. That means you could carry legally in all 50 states, even in restrictive jurisdictions like New York, California, and New Jersey, where regular citizens struggle for years to get licenses or are denied outright. Traveling from California to New York? Your carry rights follow you the entire way under federal protection. So what does it take to qualify for LEOSA in 2026? You need to have served at least 10 years in law enforcement, carry an official photo identification from your former agency, and complete a firearms qualification course once per year. That's it. Some states have tried to challenge this federal authority and impose additional restrictions. New Jersey attempted to force retired officers to apply for state permits anyway, but federal courts struck those challenges down decisively and unambiguously. LEOSA stands strong, and it overrides state-level restrictions entirely. The surprising and genuinely frustrating part? Many retired officers have no idea this federal protection exists or never take the steps to get their LEOSA credentials properly established. If that's you, if you put in 10 years or more in law enforcement and you're not carrying under LEOSA, reach out to your former department's administrative office immediately. Once you're certified under LEOSA, you've got nationwide concealed carry rights that most civilians could only dream of accessing. Don't leave that protection on the table. Here's something that happened just a few years ago that almost nobody outside the gun rights community even noticed, and it's one of those stories that should have been front-page news but got buried because it didn't fit convenient political narratives. In 2017, Congress shut down a federal regulation that could have stripped Second Amendment rights from thousands of seniors receiving Social Security benefits. This deserves your attention because it reveals exactly how close we came to mass disarmament of older Americans without any judicial oversight whatsoever. Here's what was happening behind closed doors while most Americans were completely unaware. A regulation introduced under the Obama administration was set to automatically label certain Social Security recipients as mentally unfit to own firearms, not because of any court ruling, not because of any medical diagnosis of dangerous mental illness, but simply because they had designated a representative payee to help manage their monthly benefits. If you needed assistance balancing your checkbook or managing your Social Security income, the federal government could have added your name to the FBI's prohibited persons list with no hearing, no judge, and no opportunity to defend yourself or present evidence. But in February 2017, that rule was repealed by Congress before it ever took full effect. It was a significant win for gun rights and for constitutional due process protections, and more importantly, it established a critical legal precedent. Needing help with financial management does not mean you lose your constitutional rights without a formal legal proceeding. The problem? Most seniors never even knew this regulatory battle was happening. They had no idea they were potentially weeks away from being administratively disarmed by a bureaucratic rule that completely bypassed the court system. And if you're not paying close attention right now in 2026, a similar regulation could be reintroduced under a different name or through a different administrative pathway. So stay sharp, stay informed, and always question policies that attempt to strip your constitutional rights without giving you a voice or a hearing. Finally, here's a benefit older hunters need to know about that could save you time and money. You might be completely exempt from modern hunter safety course requirements and don't even realize it based solely on when you were born. If you were born in the 1950s or early 1960s, there's a strong chance you've already earned your way around mandatory training programs based solely on your birth year. Many states have built-in age-based exemptions for hunter education that are written into law but rarely discussed or advertised. For example, in Georgia, anyone born before January 1st, 1961 is automatically exempt from taking a hunter safety course. Other states follow similar models using cutoff dates tied to when mandatory training programs were first implemented, usually sometime in the 1980s or 1990s. Why do these exemptions exist in the first place? Because back then, firearms safety wasn't taught in government-run classrooms with standardized curricula and certification cards. It was learned firsthand, passed down from parents, uncles, and grandparents out in the field during actual hunts. That kind of practical, real-world experience carried genuine weight and credibility, and lawmakers recognized that. This exemption matters most when older hunters decide to return to the sport after years away from it. You start researching the current licensing process and see that a hunter education certificate is listed as a mandatory requirement. But what the licensing materials don't say prominently, what's buried in footnotes or fine print at the bottom of web pages, is that your birth year might make you automatically exempt from that entire requirement. So before you spend time and money enrolling in a class you might not legally need, do a quick verification check. Visit your state's wildlife agency website and look specifically for hunter education exemptions based on age or birth year. Verify whether you qualify for an automatic waiver. You might discover that your birth certificate is the only documentation you actually need. And there you have it. 10 powerful firearm rights built specifically for seniors, protections and benefits written into federal and state law. And yet the vast majority of older gun owners have never heard of a single one. From lifetime concealed carry privileges for retired law enforcement officers that work in all 50 states to hunting license exemptions you may have qualified for since the day you were born. These aren't clever loopholes or legal tricks that exploit technicalities. They're real protections written into law by legislators who recognize that age and experience deserve recognition and accommodation. But here's the part that should make you absolutely furious. The system actively bets on your silence and your ignorance. Government agencies, firearms retailers, and even advocacy organizations that claim to fight for your rights are counting on you never asking the right questions. They hope you'll pay full price, jump through unnecessary hoops, and follow rules that don't even apply to you anymore. Every dollar you overpay, every class you take that you didn't actually need, every right you don't exercise because nobody told you it exists, that's a win for a system that profits from your ignorance and your compliance. Don't give them that win. If this video opened your eyes to protections you didn't know you had, if it revealed savings you've been missing out on for years or even decades, then hit that subscribe button right now. This is where we break down the laws that matter, expose the fine print that gets deliberately hidden from ordinary Americans, and give law-abiding gun owners the knowledge they've earned and deserve, especially the ones who've spent a lifetime following the rules and respecting the system. Subscribe, turn on notifications, and share this video with every older gun owner you know. Your parents, your grandparents, your shooting buddies, your hunting partners, anyone who's been in the firearms community long enough to have earned these benefits but might not know they exist because nobody profits from telling them. Knowledge is power, and constitutional rights only matter when people actually know about them and exercise them. The system counts on you staying quiet and uninformed. Prove them wrong. Stay prepared, stay protected, and most importantly, stay informed. These rights are yours. You earned them. Now use them.